Good morning, all.
Good morning.
All right. Welcome to the Legislative Committee on Administrative Rules, April 25, 2024. First item to go around and introduce ourselves, and I'll start to my left here.
Jen Kirby from the Office of Legislative Counsel.
Representative Mark Higley, I represent the Orleans Lamoille District.
Senator Chris Bray, I represent the Addison District.
Senator Dave Weeks, representing Rutland County.
Ginny Lyons, Senator representing Chittenden Southeast.
Mark McDonald, Senator representing most of Orange County.
Representative Trevor Squirrel representing Jericho and Underhill.
Darlene Bidwell, Assistant.
Shire Administrative System.
Okay. Next up, minutes from April 11, 2024. A motion to approve. Discussion. Those in favor, please say aye.
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 Opposed? Okay, thank you. All right, first, rule up here is 24 E04, Emergency Rule, Department of Children and Families, eligibility criteria for temporary housing assistance. We have Heidi. There's Heidi. You have the floor.
Good morning. I'm Heidi Moreau, Policy Advisor for the Department for Children and Families. I'm joined by my colleague Nicole Touziant, the Economic Benefits Director for Economic Services Division of DCF. So the Budget Adjustment Act extended eligibility for certain categories of people. This first rule addresses eligibility for individuals who are eligible under the catastrophic and vulnerable categories. And under the Budget Adjustment Act, the 84 and 28-day limits were removed, but households were still subject to the remainder of the rules as amended by the Emergency Rule 23E12 that was adopted back in October, and any identical emergency rule subsequently adopted. So 23E12 expired March 31st. So the department filed this new emergency rule that is identical to the rule filed in October to take effect April 1st. And I'm happy to answer any questions the committee may have.
Okay, I have a quick question. The permanent rulemaking, what's the status?
We are at the final proposed rule stage. We're just waiting for a signature on the rule packet, and then it will be filed with Lcar and the Secretary of State.
When do you expect that to happen?
Within a few weeks.
Takes a month to get a signature?
It can take a while.
Okay, thank you. Senator Lyons.
Thank you. So these are emergency rules. Nevertheless, they were directed through legislation. I think you've identified the budget adjustment. We have a Budget Adjustment Act. We also have Act 81. And the GA program itself doesn't really have housing in it, permanent fixture. So those two, the legislation that we passed through either the budget or Act 81 last year would guide the rules that are here. And I'm wondering how, so that's just a comment. And I think we'll hear testimony a little bit later from folks about that. But the issue here for me is we're also currently passing legislation that relate to emergency rules and some for the next year, perhaps could be in perpetuity, depends on the conference negotiations. And what you've put into the rules are that it's a 28-day period. And does that 28-day period correspond with underlying statute from BAA or Act 81? One question. And two, how will you accommodate changes that are made in the current discussion that's going on within the budget conference process, or that will happen in the budget conference?
So to address your first question about the 28 days, that that time limit was in the rule, the permanent rule as it existed. So this emergency rule only includes the same amendments that were made back in October, which included giving the department authorization to withhold payment if a motel was in violation of lodging licensing rules, and expanding eligibility for families with children age 18 or 19 if they're in school, and revising the methodology for calculating the income contribution. So we didn't touch any other parts of the rules in this emergency rule filing. It's identical to the one that was filed in October. And this emergency rule will only be effective through June 30th so that we can respond to any changes in legislation.
Thank you. I'll hold my questions till later.
Okay. Any other questions for Heidi on EO4? Okay, thank you, Heidi. Oh, Representative.
I do have a question in talking about your economic impact here in regards to expanding eligibility to families with children up to age 18 and 19. Can you tell me what the reasoning was around going as high as 19, 18 and 19?
So that stemmed from the executive order that was passed last May and was incorporated into the emergency rules that were adopted at that time.
Okay, and then I guess on that front, my understanding is there was a little over $11 million in the budget adjustment for the continuation through June 30. It looks like the current eligibility in emergency housing is a little over 3 million. Additional $400,000 for that extended eligibility. And I guess what's the rest of the money going towards?
I'm going to turn that.
I'm sorry.
I'm going to turn that over to Nicole to answer that question.
And I will need to talk to our business office and respond back to you at a later date. I do not have that answer ready today.
Okay, thank you.
Senator Weeks.
Just curiosity. So in 24E04, it also refers to the legislation about participants providing 30% of their income during that period. I'm wondering how that worked. If there was any, what you experienced, did that actually transpire? Was it successful or was it unsuccessful? Just some kind of indication of what happened with that particular aspect.
So prior to the emergency rules that were filed last year, the income contribution was calculated based on the lowest available price, and in response to feedback from advocates and housing organizations, we learned that individuals were actually spending more than 30% of their income because of the way that calculation was done. So I can, if Nicole has anything further to add about how successful that has been, I'll turn it over to her.
Thank you, Heidi. So yes, it's a change in how many nights a client needs to self-pay for. Under the emergency rule, they pay for fewer self-pay nights than under the old methodology.
Yeah, that's not very clear. So I'm curious. I'm curious if the state actually received any of the funds from the participants up to the 30% rule or whatever you just referred to. Did that actually work or did that not work?
So the state does not receive the fund. The way that it works in practice is that when a client has income, they are required to pay for some nights to the hotel directly. So the state does not pay for those hotel nights. So for example, a household that has disability income, which is around $1,000, 30% of that would be $300. And if your average hotel cost was $100 a night, then they would need to self-pay for 3 nights to that hotel. So ESD would not pay for those 3 nights. The client would pay for those nights directly. Under the new methodology, we look at the average hotel cost as opposed to the lowest hotel costs. And so the number of self-pay nights is fewer than it had been in the past.
Right. But I'm asking, were there actually,
Gonna happen.
did it happen? It's a pretty straightforward question. Did it?
Yes, yeah, clients do self-pay. They have the option of either paying for the hotel themselves or finding alternative options, but clients do self-pay during their self-pay nights, yes.
Okay, can you characterize it like 10% of them did or 90% of them did or,
I do
I'm just
not
trying to
know
get
how many actually stayed in the hotel versus finding alternative solutions.
Okay, thank you. And then just the second question, if I could. I've kind of lost track on what the cost of the room was. Is it now 80 or is it 150 per night? Where are we now?
Under the Budget Adjustment Act, there's an $80 cap on hotel rates. So the current cost today, $80 per night.
That's it. Thank you. Thanks.
Any more questions for Heidi at this point? Okay, we have
Michael Benvenuto.
Michael Benvenuto from,
I was going to testify on both rules combined. Should we do the department on the next rule and then we'll testify?
it's really your option. You want to withhold until the next rule?
Yes.
Okay, and is that true for you, Brenda, also?
Yeah, I was gonna also testify on both roles combined.
Okay.
Yeah.
So you'll do the same thing.
I will do the same, yes.
Does that require us to hold the vote on 04? Hold
We
on.
can do that. Let's.
I'd like to hear what,
Yeah, let's listen to EO5 and then let them speak and then we'll have our discussion and vote on both of them. Are you okay with that? Fine.
Good with it.
Heidi, why don't you go to EO5?
Okay, so similar to the previous emergency rule, the Budget Adjustment Act extended eligibility for individuals who were eligible for the Emergency Housing Transition Benefit under Act 81 through June 30th, subject to the eligibility criteria in the Emergency Rule 23E11 that was adopted back in October, or any subsequent identical emergency rule filed. That rule also expired March 31st, so we filed this new emergency rule that is identical, but for a footnote that was added to explain that the benefit is being extended through June 30th, and that rule took effect April 1st.
Ready? Questions? Seeing none, thank you, Heidi. Then we'll hear from Michael.
Here.
That's fine.
Good morning.
Morning.
I am Michael Benvenuto. I'm the director of the Elder Law Project at Vermont Legal Aid. Vermont Legal Aid represents participants and applicants in this program. We have a long history of representing individuals who are experiencing homelessness. And we've been working on this issue for many years now as the program has sort of moved through different changes. And I testified last year about these emergency rules when they first came up, and I testified in the fall. This committee actually objected or asked the department to revise the rules that were proposed last summer based on the concerns we raised last summer. So we're back here again. First, I just want to talk about the process. I know this is a legislative committee on administrative rules. There is no legislative justification at all for emergency rules. So there was no exception to the APA. The BAA did not grant any authorization to do rulemaking or any authorization to bypass normal rulemaking or to do emergency rules. So you hear today the department has offered no justification at all for emergency rules or their rulemaking process. But secondly, and more importantly, they did no public notice or comment at all about these rules. The Budget Adjustment Act was passed March 1. It was signed March 13th. These rules are into effect April 1. We would have scrambled to comment on these rules. So we would have raised the concerns we're going to raise with you today about the implementation of the BAA if they'd given us the opportunity for comment. So if you look at the rule packet, they offer no explanation at all as to why they did no public notice or comment at all. They're treating this as an entirely a routine extension, but that's not what the legislature intended, and it's not what's happening on the ground. And so, our concerns we didn't have the opportunity to raise them. This is the first time we've been able to talk about what's really going on. And it's been, Brenda Siegel will hopefully get a chance to testify. It's been very chaotic, disorganized. It's super confusing what they're doing. And it relates to just how the department, the sort of disorganized method in which they're administering these benefits and what they're telling people and how they're doing that. So what they've done is they're extending two emergency rules, the modification of the GA rules from last summer, and then the cohort group, which is the transitional housing benefit. So they have those two population groups in motels, but they're treated under different rule sets. But then the BAA authorized a third group, which we'll call like the disability variance group, which is the BAA created the ability for people with disabilities to request emergency housing based on their disability. So by the department just treating this as a routine extension, they've created three different population groups in the motel health program with overlapping, inconsistent rules. And I should also say they've put out nothing, at least that we've seen, in writing. We're looking for rules. This is the rulemaking committee, but even if we go below rules, there's nothing that explains what they're doing. There's no document from the department that explains these are the three population groups. These are all the rules that apply to you. This is the 30% methodology for your contribution for income from April 1 to June 30th. They don't explain, there's nothing in writing about how the disability variance process works, about how they determine whether that's a qualifying form or a qualifying disability, or when they deny somebody or they conclude that they don't meet that standard. There's nothing about how any of that works. And then fundamentally, I'll talk about the due process and notice issues. When people are found eligible for motel housing, they don't get any notice at all about what they're getting. No notice really about what program requirements apply to them, what obligations are expected of them. There's nothing in writing. The department's not published anything that explains, like, you're in this program, these are your beneficiary rights, these are your obligations. And then they're terminating, denying, exiting individuals for not complying with requirements that they have no idea what applies to them. They have no idea which of these three groups they're in because they're not told. They have no idea about which obligations apply to them. Brenda will talk in a minute about something called coordinated entry, which was a good idea. It stems from for the cohort group, which is kind of this idea of, she'll be able to explain it better than I do, but participating in opportunity to transition into more permanent housing. But there are huge wait lists to participate in that program. And so people are trying to sign up, but they can't get in. And they're being exited right now and put out on the street because they can't comply with that requirement. Because there are wait lists, so they can't enroll, or there are barriers to enroll, or their disability makes it inappropriate for them to be enrolled. And the coordinated entry requirement does not potentially apply to two of the three groups we're talking about. It's not part of the traditional GA program. It's not part of the disability variance group. So even understanding from our perspective as legal aid lawyers looking at these cases, we don't even know like what governs anyone's participation in this program, because the department is just operating basically in chaos. In terms of, like, we expect them to write out and clearly articulate what people are expected to do, and they've not done that. And these rules don't define that. So I guess the last thing I'll talk about is the legislative intent of the Budget Adjustment Act, because that's really the fundamental disagreement here. The Budget Adjustment Act, very simple in its language, basically put an obligation on the department to ensure emergency housing for these populations. It did not extend the changes to the general assistance program. It did not exchange the cohort program. It said for people who are eligible for general assistance as expanded, for people who are eligible in the transitional housing group as defined, you will ensure they have emergency housing through June 30th. And for people who qualify based on the disability variance. So the BAA housing is really a unified population group in which the department is supposed to ensure their emergency housing. It was not split up into three, even if people could qualify under the different bases. And so they've not complied with the legislative intent of the Budget Adjustment Act. They've not insured emergency housing for these groups. And in fact, the BAA says insure housing through June 30th, but how long somebody is certified for, what they have to do to reauthorize, what they have to do. They'll authorize somebody for a day, like we're hearing about people like, say, for May 1. Those individuals don't know their benefit ends May 1. They don't know what they need to do to reauthorize May 1. Somebody's going to show up banging on their door on May 1 and say, you're out, you didn't reauthorize. But that's in part because they didn't understand, those obligations were never laid out to them. They were never given an explanation of the program. They were never getting written notice. When they exit somebody on May 1 for not reauthorizing, they don't get a written notice adequately explaining even what the basis for that is and what they can do. And they may tell the person, like, call the department. And then people are, on these days where there's mass exodus, people are calling the department, they can't get through. It's just, so that's the problem. So the intent of the Budget Adjustment Act was to ensure housing for these super vulnerable individuals. The legislature's done. We commend you an incredible job of protecting this population group through sort of this transition crisis. But the department's implementation of that has been inadequate. So I guess my request for you is either you don't approve these emergency rules, or you express your concerns that this was not the intent of the legislature.
Senator Lyons?
Thank you for your comments. All we can do is pass legislation that asks for consideration of our most vulnerable and ensure that they are helped at least through June 30th. And then legislation that's currently in action or in play will perhaps resolve some of the problems that you're talking about in terms of communication, case management, and so on, because that is embedded in the budget language. So some of the things you're bringing up were not considered during the BAA, or in fact 81. What was considered are the people who have disabilities, and you've referenced that here, or folks who are most vulnerable. I am sympathetic to your comments regarding due process. I think that would be important. And the communication piece, as you said, we've all been aware of the need for greater communication, 211, or however that happens. So, but in terms of getting us from here to June 30th, the rules will help do that. The implementation is not in our hands at this point, given what the legislation said. It didn't have all of the guidelines and suggestions for care, case management and so on, but I am sympathetic to the comments you make.
Other members? Senator
Is it appropriate to have the department respond to the?
Sure. Heidi, would you like to respond? Or Nicole?
Nicole, would you like to speak to the communication piece?
So specifically on communication, DCF is working to improve the communication to clients. Just this week, we sent a letter to clients reminding them of the need to renew at the end of their authorization. Part of the reason that we did that is because at this time is because many households do end their authorizations at the beginning of the month, around the 1st of May. We do have more households that need to renew just because of when income is received, especially for SSI and SSDI. So we sent those reminders out. We do outbound calls as well, but we have found that those aren't as effective. We cannot always get a hold of people. So, and we plan, as the budget language is approved and becomes law, we'll have communication about what the program looks like for July 1st as well in the upcoming months.
You all set? So,
Can I just respond to the?
I'm sensitive of time here. I want to make sure that Brenda gets an opportunity to speak. And why don't we do that first? And then we'll open up for additional conversation.
We call people who don't have living houses households. We refer to these groups as households.
Yeah.
Well, That's the word that's being used, but they don't have houses. That's why we're here. It just seems to be a inability culturally to deal with what we're dealing with. So
Perhaps
maybe that's,
family unit, something to that.
well, but yeah,
Brenda, you all set?
yeah. To the extent that one can be all set under these circumstances.
Agreed. Good morning. For the record, I'm Brenda Siegel. I'm the Executive Director of End Homelessness Vermont. Also, I do consulting on human services issues, and usually when I do that work, it's on rules, systems, and laws, and you don't hear from me as much on those, but they come up when we're talking about rules. For those of you that don't know, most of you do, End Homelessness Vermont is a lived experience-led organization that works towards the goal of ending poverty and disability discrimination and homelessness in Vermont. We provide a data-driven safety net to the safety net, and our trauma-informed, rooted in compassion, empathy, and housing first principles. And we effectively specialize in working with people with disabilities and people who have complex situations. Our organization is unique as it relates to GA emergency housing, in that I read and understand all of the rules and interpretations of those rules, which equals roughly 500 pages, as well as any emergency rule and changes as they come up, because that allows us to support someone who is wrongfully denied in a fair hearing, or supporting them through the process, and especially supporting people with disabilities in help with reasonable accommodations or issues surrounding access to their shelter that they may be wrongfully denied in general. We've run this hotline additionally since 2021. And I take cases on my own when there's an extremely complicated case or an extreme disability that will require representation in a fair hearing or a reasonable accommodation. I have roughly 91 clients that I renew their vouchers every month. And there's about 300 clients who we provide other kinds of ongoing support for in our organization. We don't turn anyone away. So if someone calls, we do everything in our power to offer some kind of support for them. So everyone on my ongoing list has a significant disability. So that's important to understand as we're talking about this. I'm going to just echo that there's a violation of the Administrative Procedures Act in the way that these rules were created. An important part of my job is knowing and understanding this. And it's a complicated maze that only a select few know backwards and forwards. And I would, outside of the Agency of Human Services, I think that includes Vermont Legal Aid and myself. A major concern that I have is that the Department of Children and Families and the Agency of Human Services is setting these rules without the time for public comment. And that means that there is no time to address concerns we may have on the impact of these rules, not to mention is required by law. You've already heard when the Budget Adjustment Act was passed and signed, but what you don't know perhaps is that these rules were put into place on April 3rd, but required to be followed retroactively on April 1st. There's no opportunity to fix something that was not possible to execute for someone with disabilities. And I want to describe some examples. I have some troubles with my eyesight, so I apologize. I want to describe some examples that we come across leading up to the April 1st deadline for those who were members of the cohort. People living in our client list, living with disabilities, I'm going to come back to that. Because the Department of Children and Families elected to provide absolutely no communication to people in the program until April 5th, many people in this category believe that their benefits were ending on April 1st. There are many hoops and rules for people in the cohort, but many individuals had transitioned to trying to address the crisis of their looming unsheltering, which meant that no longer keeping up with the complicated rules of the program. The department could have communicated with people on March 1st, March 13th, or any subsequent time since the passing of the BAA. Suddenly on March 29th, the Friday before April 1st, at 1:30 in the afternoon, people received a chaotic 3-line note posted to their hotel owner as instructed by Economic Services that told them to renew before April 1st with no explanation about their extended benefits. For those who don't know, a late afternoon call to Economic Services is most often not a fruitful one because of wait times. When people called, they were denied. Why? Because they were not following the rules or they hadn't kept up with the requirements of the program, a program that they still had not been told was being continued. That morning, our hotline received 100 calls by 10 a.m. due to confusion. Our organization had provided communication to people in the program to let them know that they could renew. But when they called, we had no idea that these rules were being continued. So when they called, we didn't know to inform them to continue with these processes. Going back to the people with disabilities. So the majority of our clients are living with disability, and that is extreme enough, so they need ongoing support. They are individuals who may not survive when the program ends and whom we have no solution for. I know that there are many more with these challenges in the program who have been removed from the program due to their disabilities. Public comment periods are extremely important to people living with disabilities because it allows them and those of us who work with them to comment on the places where the rules may provide an impossible barrier to them accessing benefits. By providing no time for public comment or comment of key stakeholders, it means that people with disabilities are struggling to have their needs met. They are being required to participate in things that are not possible. For example, for a person with dementia or living with a severe psychiatric disability, or because they lack the ability of access due to other parts of their physical disability, then their shelter would be denied. While the law requires a reasonable accommodation, the rules do not accommodate this part of the American with Disabilities Act and cannot be addressed reasonably when no time for public comment is offered. So that is how it impacted people in the cohort and subsequently people who are in regular GA. Throughout the months of both March and April, the department has made it exceedingly difficult to get through the maze of barriers being put up as people try to access their shelter. I have never had a more difficult time working on the vouchers than I am right now. And I can tell you that assuredly. They have both used existing 2600 rules and emergency rules, interpreting them in a more restrictive and harsh way, and made up rules to create these barriers. For example, people in regular general assistance emergency housing are not required to participate in coordinated entry. We do encourage our clients to participate in coordinated entry, but it is not a requirement. It is only a requirement of the cohort, and it will be a requirement after the budget passes, but it isn't now. Either way, it is not anywhere in the 2600 rules. When I asked about it, I received communication from the department that concurred that it was not a requirement, but then a subsequent communication that told me that the requirement was, quote, implied by a rule that says, quote, applicants are expected to take steps to avoid or resolve emergencies in the future without GA. This is a weird and archaic rule in the first place, but also clearly doesn't apply here. And it pains me to have to explain this, but now is not the future. And once you are housed, you come off of the coordinated entry list. So this particular step, once you're housed, does not resolve future emergencies without GA. It literally does not apply to the future at all. It helps you to resolve your current homelessness, and that's why we encourage it. But even if it did, there are many steps that one can take that are just as or more meaningful to resolve emergencies in the future. Most importantly, this is not a rule. Anywhere, the department can't just make up this rule. Yet they are. This is impacting individuals in the program who are housed under GA, they have not been told or only recently told of the requirement. They have not had a return call from a lead agency. They have not been able to get through to a lead agency. They have a disability or dementia that is preventing for their participation, and they are long waiting list in some areas. Most importantly, though, it's just not a rule. It doesn't exist. Our organization's main concern, I'm almost done. Our organization's main concern is that this has become the Wild West in rulemaking currently. The Department of Children and Families is being allowed to do this whenever they want and whether the rule is there or not, and it's impacting people in the program in enormous ways. We request that the legislature direct the Department of Children and Families to, 1, adhere to the Public Administration Procedures Act and provide time for public input now and in the future. 2, be directed to not make up rules that do not exist by widely stretching and twisting current rules. Or three, provide adequate, reasonable accommodations for people living with disabilities and medical vulnerabilities that prevent them from being able to adhere to these rules. Perhaps add what those are in the rules. Thank you so much for your time, and I'm available to answer questions.
Any members? Representative Higley?
Real quick, coordinated entry, can you explain that to me?
Coordinated entry is a little bit of a complicated process, but often helpful. It's lead agencies sign people up in a very long interview. It can be up to 2 hours, which is why someone with dementia or psychiatric disability can't do it and may not be able to do it. And then they're on a list, and oftentimes housers will get people off of that list to house them. But someone with a severe psychiatric disability or dementia may not actually that may not even be a beneficial activity for them because they may need assisted living or a facility of some other kind.
Thank you.
I had Senator McDonald, then Senator.
Your testimony suggests that things are not working.
That is correct.
And you've much more experience around this than any of us here at the table. Is the reason they're not working that the people that are supposed to carry this task out are overwhelmed? Are they indifferent? Are they fundamentally opposed to what they're being asked to do? Where is the failure in the system that we have that isn't providing what we say we believe by law should be available?
Well, I think that the Budget Adjustment Act was very clear in its intent of the law, and I don't think the intent is being carried out correctly. If you ask my opinion of why that is, I would say that the administration, the governor, is opposed to this program, and which makes it very challenging for the department. So I have a lot of sympathy for the people working in the department. However, I believe that it's extremely hard to there's no reason for it to be done in such a chaotic and not trauma-informed way. There is no reason why people with disabilities are not being given their legally afforded right with the American Disabilities Act for reasonable accommodation. And there is no reason why they are not working with providers and making it more simple for us to do this work on the ground. They are not doing this work adequately with us on the ground. So that's what I guess my answer would be.
But you say you're saying there's no justification
Right.
for it not being done.
Right.
Is the reason that it's not being done.
Well, I would say, I don't know why it is. We are a 3-person organization, and I have provided communication every single week to people in the program. I do not understand why the department has not been able to do that. I can't justify that or come up with a reason because it doesn't make any sense to me. If we can do it as just a tiny organization, then they certainly can do it with all the staff that they have. So I have no answer because I don't think there is one.
We are here as a committee to recognize and deal with things that are not working according to the procedures that we have available to us.
Right.
But frankly, Mr. Chair, I find this alarming, but this is not unique to Vermont. It's been going on other places at the same time.
Homelessness has, but I have done a little bit of research throughout the country on this issue, and the unwillingness to create a comprehensive plan, the lack of following the administrative rules, the unwillingness to follow the intent of the legislature when they pass a bill, those things other states are doing well, actually, even when there is 2 different parties running our different parts of our government.
Thank you, Mr. Chair. Senator Lyons?
Okay, I actually don't have a question, but I do want to say thank you for your work and for the information that you bring to us when you come into our committee. So I'm going to move aside from that. And I do want to say that a lot of the issues that we're getting into through the testimony, both from Michael and from Brenda, is testimony related to the underlying policy and how we move forward in solving a problem that's been going on for a long time. I mean, I will reiterate that 3 years ago, we looked at rules and we sent them back. We had a joint hearing and meeting with House Human Services and Senate Health and Welfare. We had a BAA. We had another joint hearing with House Human Services and Senate Health and Welfare. We had another BAA and Act 81. And now we're going through another process with a full general assistance bill in both the House and the Senate that is looking very broadly at this policy. We are now looking at that within the context of the budget and will be conferenced out. Many of the concerns that we're hearing about are the concerns that we've heard about in our committees of jurisdiction and policy decision-making, as well as in appropriations. So we're not going to solve all those problems with the rules. The rules process is one thing. I think we're at a very short timeline. It's about, June 30th is a month and a half away. And while a lot of the criticism is being made of the agency, and we know that what you're doing with folks with disabilities is really significant and outstanding. And I do agree that there should be some partnership that would help with that. But the staff at the agency have not been directed to do the case management. That is something being discussed in the budget. And the communications piece perhaps requires additional support within the agency. So I can defend on both sides of this because I see where I have seen where some of these problems lie. But in terms of having a process where folks should be allowed to speak, I think that's an important consideration and perhaps something we can talk about as we move forward. But I did want to ask Ledge Counsel on the screen if there were any comments, Katie, that you wanted to make as we're looking at these rules with regard to how they fit with legislation that we've passed.
Sure. Good morning, Katie McGlynn, Office Legislative Counsel. Nice to see everybody. I would start by agreeing with your comments, Senator Lyons, that this committee in particular sort of sees the consequences of policy choices that are made by the General Assembly. One of the policy choices is that there is no static emergency housing program that exists in statute. Rather, emergency housing is dealt with every fiscal year in the budget and again in budget adjustment, which means there are lots of opportunities for the benefit to be adjusted and therefore requires additional rulemaking. And whenever there's additional rulemaking, there's an opportunity for there to be potential misunderstandings of what is written in statute and opening a debate as, each time a budget and budget adjustment is passed, we have sort of a new conversation about what is in the most recent budget and budget adjustment. So a lot of this conversation makes me think that that is part of the underlying issue. In terms of budget adjustment, the budget adjustment language itself did not direct emergency rulemaking. However, given the fact that there's sort of a 3-month window between for the period that budget adjustment is meant to cover through the end of the fiscal year, there wouldn't be time for permanent rulemaking. So my understanding is that emergency rules are being used to avoid the absence of rules during this period, and that permanent rules have been filed and are, I believe, will be in the process shortly, is the email I got from DCF. The emergency rulemaking has a lower threshold for public participation. And I think those are some of the comments that you're hearing today, is that emergency rulemaking was used, which has a lower threshold for public participation. If there are any questions, I can answer that, but those are my general thoughts.
No, those are terrific, and which is why I think we're hearing some of the fallout from not having a transition plan into whatever our full program is, which we have been asking for from the administration, but I can't, so now within the budget, there may be an opportunity for us to move forward in a way that we haven't. But we may be back with this again next year, but thank you. Thanks a lot. That helps.
Representative Higley.
Thank you, Mr. Chair. This is just a general comment in regards to, I'm not, apologizing for any agency, but seems to me the agencies that I've called throughout Vermont, regardless, and even legal aid, get a recording that says, we'll get back to you within 24 to 48 hours. And to me, that's an issue, I guess, of not enough staffing or whatever it might be, but it certainly is frustrating for anybody, whether you call the Secretary of State's office, whether you call unemployment, you name it, that's what you get. And it's for individuals, and whether you're homeless or not, it's certainly frustrating.
Okay, we're at a place here where curious where the committee wants to go with the two emergency rules. I think a lot of the conversation we've had here is a good conversation. It's an important conversation. A lot of it is policy driven. That's not our rule here as a committee. There is permanent rulemaking that's in process, and I know that there's some direction being offered in the budget around where we go with this benefit of the program. So I'd like to ask if the committee wants to call the question on the two rules.
I'd like to move both. I'd like to move 24E04 for approval.
Any additional conversation? Senator Weeks.
Just for clarification, 04 is about the 18 and 19-year-olds.
That was
kind of
first,
a unique
that was the first one we did, yeah.
Yeah.
Any additional conversation? All those in favor, please say aye.
Aye.
Opposed? No. Okay. Is that
Okay,
four? You didn't vote? Aye, okay, so 14. Senator
I'd
White?
like to move 24E05, emergency housing transition benefit.
Any discussion? All those in favor, please say aye.
Aye.
Opposed? Thank you. Doing a time check here.
I have,
What's that?
I'm gonna have to leave.
Yeah, so, and we have two chairs here, and apologize to James. You there, James?
Morning.
We find ourselves in a place where we don't have time. So
That's-
I'm looking at this, we have a 45-day review period that ends on 5/2.
Next meeting, as we discussed, will be May 16th.
Yeah, we're trying to meet next time on May 16th. Would you be willing to give us an extension? Your adoption period is not until September, right?
We're hoping to have these rules effective by July 1, so long as we can move by June 15th. Now, as you heard,
Okay.
sometimes it takes a while to get the secretary's signature on a rule at the Agency of Human Services. But I
And if we
think
did-
if you, go
Okay.
ahead.
So if we do it on the 16th, you feel like you'd have enough time?
I think that should be plenty of time, yes.
And you're willing to do that?
Yes.
Okay.
I will say, just so that the committee knows, we might have to put the proposed reimbursement manuals out for public comment through the Agency of Human Services Medicaid Policy Comment System on
Okay.
May 15th. But we can always take that back. If the committee doesn't go with, doesn't approve going in this direction, we don't have to do stuff we put out for public comment. So I just wanted to alert you, we might have the manuals out for public comment before the committee acts, but we're happy to make sure that we're allowed to do what we want to do before we actually do it.
I hear you. And we'll make sure you're first on the agenda next time.
Thank you very much. Thank you for your time this morning. And of course, totally appreciate some issues take more precedence than how the bean counters crunch their numbers. So we, you
All
know,
right.
totally fine. Thanks,
Thank you.
folks.